Thank you, Chairman. I wish to speak in favour of this bill. This bill introduces a number of important and welcome changes to the regime for the implementation of community service orders in this state. Firstly, it increases the time, the sentencing period in lieu of which a community service order can be made from 6 months to 12 months. Equally importantly, I'm sharing time with Deputy Lyons. Thank you very much, Chairman. Secondly, while sentences in excess of 6 months are rarely handed down in the district court, although it is of course possible for the district court to hand down 12-month sentences in certain circumstances, the bill explicitly provides that community service orders can now be made in the circuit court, which is a very welcome amendment to the regime. And I think most importantly, the bill provides that judges now have a duty to consider whether a community service order is appropriate. I would contend that community service orders are appropriate in a great number of circumstances for a number of reasons. Those reasons being linked to the purposes and the aims of sentencing in our criminal justice system. Those are retribution, rehabilitation, deterrence and incapacitation. With regard to retribution, I think the benefits of community service orders are clear in that a community, a crime is in essence a wrong against a community or a society. And of course a community or a society has the opportunity to see those who have committed the wrong purge themselves of the wrong in front of society and perform acts which are beneficial to the society in the form of community service orders. With regard to rehabilitation, the benefits I think are equally obvious of community service orders in that the accused or an offender, as they would be at the stage of sentencing, has the possibility to remain in their community and draw the support from their community, and indeed the support from their family as they seek to deal with the wrong that they have committed. And as regards deterrence, as somebody who has worked in the criminal justice system, albeit briefly, on the southwestern circuit of this country before having the honour of being elected by the people of Clare, it always struck me that for a number of offenders, particularly minor offenders, that our criminal justice system, and in particular the possibility of a very minor and short sentence in prison, didn't actually act as a deterrence. I think anybody who has sat in the criminal courts of this country, particularly in our largest cities, could only be struck by the bravado of young offenders and indeed older offenders as they awaited sentence for relatively minor offences. Of course that bravado could be just apparent bravado, but it is, I think, in certain communities, and those communities are of course communities which have suffered neglect since in certain instances since the foundation of this state. But for those communities, and in some of those communities, it is a great regret, it is with regret that I say that a minor sentence is almost a badge of honour. And certainly going to some of our prisons for certain individuals from certain communities in our state is something that is almost welcomed. These individuals are people who are in many cases habitual offenders, but of course every habitual offender starts with the first offence, a second offence, a third offence, and I do think that a sentence of more than 6 months in prison seems at least to draw the offenders in certain circumstances, and again from certain areas of our state which are effectively under the influence of crime gangs and crime figures. It does, those individuals, when in prison for a period of more than 6 months, they are, and I speak from evidence of having spoken to young offenders who were serving more than 6 months for the first time, and were appealing that was the context in which I managed to speak to them, that they were and they feared being drawn further under the influence of criminal gangs in our state. So from the point of view that this bill increases the sentence period up to 12 months, in lieu of which a community service order can be granted and can be made, I would welcome that. I would, however, have to point to one, I would finally mention incapacitation as the fourth purpose of sentencing in our state. And of course, if an offence is of such gravity that it requires incapacitation to meet the sentence, well then obviously community service orders don't apply. But I would have to voice reservation on one point, and that is that the consent of an offender is required in order for the judge to consider a community service order. While I am mindful of the state's obligations in the protocols to the European Convention on Human Rights, those obligations being that nobody shall be required to effectively carry out slave labour, I would submit to the House that a criminal sanction cannot or could not be considered to be slave labour. I would nevertheless, and mindful of what I've said earlier, that sometimes minor offences are almost are minor sentences for relatively minor offences, in many instances antisocial behaviour or habitual minor offences, are a badge of honour. And in those circumstances, I would strongly suggest that the consent of an offender ought not be required in order for a judge to make a community service order. I believe that it is almost anathema to our criminal justice system that an offender can choose which type of sentence that is imposed upon them, whether it's a custodial sentence or whether it's a fine or whether it's a community service order. Of course, the judges, and I am also slightly concerned that the bill doesn't appear to me to require judges to give they have to say what time period that the community service order is in lieu of. But of course, if that is a very short time period, it could be given the revolving door syndrome which people talk about, and that in itself I don't believe is as negative as it's portrayed to be. But given the fact that people who are sentenced to a very short period of time may find it more attractive to actually serve that sentence, knowing that the sentence will be greatly reduced and effectively their period of incarceration will be very brief, that may be much more attractive than actually going into the community that they have offended by their behaviour and carrying out a community service order in view of that community, even though such a community service order could be greatly beneficial to the offender in question, because they will inevitably carry out something which is useful, something which is beneficial in the community, and I would contend there is a greater chance of rehabilitation in those circumstances than there would be serving short custodial sentences in certain instances where they have an opportunity to consort with people that they would have consorted with in the past in those prisons, or in groups carrying out criminal activity outside of those prisons. So notwithstanding my reservations, I do believe that this bill which the Minister has introduced, and I would like to take this opportunity to congratulate the Minister on his appointment, which is still relatively recent as we approach the first Dáil recess of this 31st Dáil. And on that note, I will hand over to my colleague, Deputy Lyons.
Thank you, Deputy.